Consumer rights in electronic contracts in Sri Lanka, lessons from European Union and United Kingdom. Actually, this research is based on my MPhil research. I'm doing MPhil in Faculty of Graduate Studies, University of Colombo. This is the roadmap to my presentation. First, the background, research problem, research objectives, questions, methodology, results and discussion, and finally conclusion. Before I explain the background, I would like to draw your attention for these two pictures. These pictures reveals the difference between expectation and reality in online shopping. You may have faced a similar experience like this in your life. The product or goods what you have actually received is totally different what you have seen in the website. So, if you don't have a proper legal remedy in your legal system, this kind of situation will lead to a serious violation of your consumer rights. So, what are the consumer rights? In 1962, former United States President John F. Kennedy declared that 4 basic rights as consumer rights. Those are right to safety, right to be informed, right to choose, and right to be heard. So we know today a consumer can access goods and services by clicking on a single button of his computer. However, as I mentioned earlier, due to the complex nature of the internet, consumers have to face some vulnerable situations other than the offline consumers in online context. Therefore, it is necessary to safeguard consumer rights in electronic contracts. This is my problem statement. Actually, in last decades, we know our legislature has enacted several legislations in order to facilitate the e-commerce sector in Sri Lanka, such as Electronic Transaction Act, Computer Crime Act, Payment Devices Fraud Act, and etc. However, none of these legislation contain any provision with regard to online consumer protection. On the other hand, the consumer law of the country basically deals with Consumer Affairs Authority Act. That act also silent about the online consumer protection issues. Therefore, this research wants to emphasize this gap, and this research investigate the lack of proper legal regime for protecting consumer rights in electronic contracts in Sri Lanka. Those are my research objectives. First one is to examine the benefits and challenges faced by online consumers. Then to evaluate the adequacy of existing Sri Lankan legal framework on online consumer protection. Third, to analyze the key features of online consumer protection mechanism in European Union and United Kingdom jurisdiction. Finally, to recommend law reforms for Sri Lankan legal system. Those are my research questions. What is the rationale for protecting consumer rights in electronic contracts? Do existing legal framework in Sri Lanka provide an adequate protection for online consumers? Third, how are European Union and United Kingdom jurisdictions safeguard consumer rights in electronic contracts? Finally, what are the reforms that can be suggested for the Sri Lankan legal system in order to enhance the effectiveness of online consumer right protection? This is my methodology. Actually, this research is a qualitative research. I used the comparative analysis between European Union and UK jurisdiction in order to investigate the developments of online consumer protection mechanisms in those countries. I used both primary and secondary data. As primary sources, I used international guidelines, EU directives, consumer protection and electronic transaction legislations in selected countries and Sri Lanka. As secondary sources, I used journal articles, research papers and statistical reports. Now I am moving for the most important part of my presentation, the results and discussion. First, I would like to discuss the benefits and challenges faced by online consumers. Actually, we know due to the flexibility, effectiveness, time saving, cost effective and many other benefits, we really attracted with online shopping and online transaction. However, it must be noted that online consumers have to face considerable amount of risk and vulnerabilities during their transaction, such as lack of information, threat to privacy, lack of system security, lack of proper dispute resolution mechanism, and etc. I would like to discuss this further. We know in online service providers collect and store vast amount of our personal information. This information has enormous economical value. Also, online consumers are in great danger to steal their confidential information like credit card information. Another challenge is lack of proper redress mechanism, because most of these online transactions are cross-border transactions. Therefore, it is revealed that online consumers have to face different challenges other than the offline consumers. So here I would like to discuss the international legal framework for online consumer protection. Here the OECD guideline for consumer protection in the context of electronic commerce is very important. It states that consumers who participate in e-commerce should be afforded transparent and effective consumer protection that is not less than the level of protection afforded in other forms of commerce. So it means the OECD guideline recognizes the equal protection for both online as well as offline consumers. Also, the United Nations guideline for consumer protection in 2015 also recognized the same protection in Article 63. Now I want to discuss the key features of European Union and United Kingdom jurisdiction. Here the European Union approach is clearly visible in Consumer Right Directive in 2011. Actually, this directive consists several progressive provisions with regard to online consumer right protection. Here I have mentioned few provisions. First one is information requirement. We know information according to the information requirements, before the consumer bound by the contract, the trader should provide relevant information such as identity of the seller, characteristic of the goods, geographical address, and etc. This information requirement make a fair balance between consumer and the trader. Second one is extension of cooling off period. The CRD has extended the cooling off period up to 14 days. It means within 14 days period, consumer can withdraw their contracts if it is not matched with what he has ordered or seen in the website. Another interesting feature of the CRD is its potential to cover contracts for the supply of digital content. As we discussed in the previous presentation, the digital contents mean data stored or produced as a digital form, such as computer programs, computer games, and etc. So this provision is one of the emerging provision in this area, which is included in the European Union Directive. The next, the United Kingdom approach. Actually, the information requirement of the United Kingdom approach could be found in Consumer Contracts Regulation 2030. And most importantly, they have enacted Consumer Right Act in 2015 in order to implement the Consumer Right Directive into their domestic law. This act is applicable to all forms of commerce contract if it is online or offline. That is very important point. Also, as discussed in the previous presentation, this act also contain the provision with regard to the contract relating to the digital contents. Also, most important, another feature is the United Kingdom has a separate legislation for data protection. Data Protection Act in 1998. This act can cover the whole online privacy issues and data protection issues which faced by online consumers. Based on aforementioned comparative analysis, now I want to analyze the EU-UK jurisdiction with Sri Lankan law. Actually, as I mentioned earlier, in Sri Lanka, our information technology law consists with several legislations such as Electronic Transaction Act, Computer Crime Act, Payment Devices Fraud Act, and etc. On the other hand, our consumer law consists with mainly based on Consumer Affairs Authority Act 2003. So, when we look at these provisions in our legislation, first the information disclosure or the information requirement in Sri Lanka, there is no specific provisions with regard to online information requirement in online contracts. However, Section 24 of the Consumer Affairs Authority Act makes an obligation to traders to display price list, but that is not directly relevant to the online contracts. Secondly, the cooling off period. Actually, in Sri Lanka, there is no provision with regard to cooling off period. With regard to consumer privacy and data protection issues, we know in Sri Lanka, we don't have a separate legislation for data protection. However, Section 10 of the Computer Crime Act deal with unauthorized disclosure of information as a computer crime. Third one is contract on digital content. As I mentioned earlier, this feature is one of the emerging or newly introduced feature. So in Sri Lankan law, there is no provision in with regard to contracts on digital contents in our IT law or consumer law. With regard to dispute resolution, in Sri Lanka, there is no provision for online dispute resolution mechanism. However, according to Section 32 and 34 of the Consumer Affairs Authority Act, it deals with consumers can make a complaint to the Consumer Affairs Council and it can be referred to the magistrate court. However, we know this kind of traditional redress mechanisms or dispute resolution mechanisms are not very much effective in online consumer transactions. Therefore, as a conclusion, I would like to say the EU and UK examples demonstrate that how those countries overcome online consumer right violation issues by enacting strong consumer protection mechanism. As a developing country, it is necessary to take relevant steps to remove this barrier from Sri Lankan e-commerce sector. Therefore, this research suggests to introduce a new legal law policy framework for protecting consumer right in electronic contracts in Sri Lanka. Thank you very much.